Hey everybody, this is Mr. Moppin coming at you with another APUSH video. This is taking a look at topic 8.1, the Civil Rights Movement expands. In this video, we're going to be taking a look at the impact of Earl Warren. Earl Warren, as you can see pictured here, will be the Chief Justice of the United States for about a generation, from 1953 to 1969. And during his time leading the court, we will see the federal judiciary move in its most liberal direction in its history, and it will be handing down rulings that are going to really redefine American civil liberties, and in many respects play a foundational role, if not a catalyst to some degree, for a lot of the civil rights movements that will be taking place during this time period. So when we do talk about the Earl Warren Court, the first case actually that you could put up here, even though we've already talked about it previously, is the Brown versus Board of Education ruling. This, in fact, was the first big case that Earl Warren had, and he will use his leadership to not just side in favor of African-American students and integrating public schools, but was able to convince the other 8 members of the court to rule unanimously. So that kind of sets a tone for where we go. I mean, his first big case is, Brown versus Board, which upends Plessy versus Ferguson and ends separate but equal in the public schools. But it certainly does not end there. We see in the case of Mapp v. Ohio, focusing in on Fourth Amendment rights. The Fourth Amendment stipulates, once again, that the government cannot use unreasonable searches and seizures as part of their activity. Well, this case basically stemmed from a woman that was had her home searched with a search warrant, but they found contraband that was there that was not actually a part of the search warrant, and so she was still arrested, but she argued that what they were there to search for was not actually what she was being charged with. And so basically she was of the mindset that the state of Ohio was violating something known as the exclusionary rule, which stipulates that any evidence that is obtained illegally cannot be used in a criminal trial. And the court will agree. The court will agree. And what this does is take what had already been a protection at the federal level from the U.S. versus Weeks case in 1914, and now bring it to the state level. So in other words, state governments cannot use illegally obtained evidence in a criminal trial. More famously than the Mapp case is Gideon versus Wainwright in 1968. The Gideon case focuses in on the events surrounding Clarence Gideon, who was kind of a drifter in Florida in the early 1960s, and he was accused of robbing the jukebox of a local dive bar. And when he was arrested, Mr. Gideon, who did not even have a high school education, had no money, could not afford an attorney, and he asked the state of Florida if the state would grant him one, and the state said, no, we don't do that. And so, as you can imagine, Gideon, will have to represent himself and go up against a trained lawyer paid for by the state of Florida, against him, and he will lose. Now, when he is sentenced to prison, he will work on an appeal centered on the idea of, what does the Sixth Amendment mean in terms of right to counsel? Does it simply mean that people can hire an attorney if they can afford one? Or does it mean that everybody is entitled to a lawyer? Well, the Warren Court is going to be saying that that right to counsel is broad, in that it must provide legal counsel for anybody that is a defendant, and that being too poor should not deny someone of that opportunity. The idea being from the Warren Court is that, in order to have a fair trial, which is really what the Sixth Amendment is all about, if you look at the different clauses in it, it's all about the right to a fair trial. Well, how can you have a fair trial if one side has a trained lawyer and another side doesn't? So that takes away from the inherent fairness of a trial. Therefore, states now have to provide lawyers for those that might need it. You also have the case of Escobar versus Illinois. This is a Fifth Amendment case dealing with protection from self-incrimination, and basically this was talking about the idea of allowing someone to be able to speak to their attorney before they are questioned. The basic gist of it is that, if you are interrogating somebody and they have not had the opportunity to speak with their lawyer prior to that, they may not be mindful of the rights that they employ, and they may not be able to properly, protect themselves in the form of an interrogation. Remember, anything in an interrogation could potentially be evidence that could be used against you. So in the Escobar case, the Warren Court is going to write that that the ability to have fair due process, which is the legal process by which the government must follow if they wish to deny you life, liberty, or property, must include the opportunity for people to meet with their lawyer before being interrogated. Now, a case that kind of goes along with this is the Miranda versus Arizona case. And the Miranda case is focusing specifically in on the Fifth Amendment's protection from self-incrimination. Ernesto Miranda was someone that had been arrested for the kidnap and rape of a young woman. And when he was arrested and he was questioned, he eventually, after questioning, copped to the charge. In other words, he admitted, what he had done. And of course, that was used to convict him in his trial. Now, after the trial, he will file an appeal claiming that he did not realize that he had a Fifth Amendment protection from self-incrimination. He didn't know that. And that if he did know that protection, then he would not have provided that information in his interrogation of the police, which they then use as evidence to convict him. And certainly, what some might say is the most controversial of all the Warren rulings in this time period, the court is going to side with Mr. Miranda and say that his conviction violated his rights. And this, of course, is going to lead to a major change in how the police, how law enforcement go about arresting people and charging them with crimes. I'm sure you've already kind of picked up where this is going. This, of course, leads to what we call the Miranda Rights, that basically before any information can be taken from a suspect, they must be made aware of the rights that they have as someone that's now been accused of crime. They have to be told that they have the right to remain silent, and that anything they say can and will be used against them in a court of law, and that they have the right to an attorney, and if they can't afford an attorney, one will be provided for them. So they're made of these very important foundational rights. We also see through the Baker v. Carr and then Westbury versus Sanders case, the idea of one man, one vote as a principle when redrawing congressional districts. The basic gist of it was that prior to the 1960s, states were able to have vastly different sized congressional districts. You could have a congressional district with 1 million people and one with 100,000. Well, if you're one voter out of 100,000, your vote carries 10 times as much weight as somebody that's 1 out of 1 million in another district. So what this says is that states now must have relatively equal sized congressional districts. And right now it's around 700,000 people per congressional district. Another pretty significant case from the Warren Court dealing with the right to prayer and the Establishment Clause is going to be Engel versus Vitale. The Engel v. Vitale case is going to be centering in on a school in New York State that had, as part of the state law at the time, the recitation of what was known as the Regent's Prayer. It was a non-denominational prayer that was recited at the beginning of each school day. Though students were not forced to recite the prayer individually, it was recited over the loudspeaker. Every student was, in essence, forced to listen at least to that prayer. Families filed a lawsuit claiming that when the school is reciting this prayer, that it is violating the Establishment Clause, and that the Establishment Clause stipulates that the government not only cannot have an official religion, it cannot endorse religion, period. And then that's where the court ruled. You know, the Engel versus Vitale case is going to add another important layer to the idea of separation of church and state in public schools. So today in public schools, the government cannot do anything, the school cannot do anything that would be promoting religion in any way. Now, that's not to say that you don't have the right to engage in individual acts of exercising one's faith, nor can the school deny you, or condemn religion per se. It basically stipulates that the schools have to be religiously neutral, not just in terms of different denominations' faith, but in terms of the existence of religion, period. And then lastly, another important court case from the Warren Court is the Griswold v. Connecticut case, which is focusing in on the ability to purchase contraception. As late as the mid-1960s, in some states like Connecticut, it was still illegal to sell people contraception. Many of these states were still following the idea that if you provide birth control contraception for people, that it would encourage lascivious sexual activity, that it would not be focused in on having sexual intercourse for the sole purpose of procreation, et cetera, et cetera, et cetera. But the court is going to rule in this case that in fact the ability to purchase birth control contraception is an important example of privacy. And this is significant because this is going to be a landmark case, because it's going to assert a right that is not enumerated. It's not like, where you have freedom of speech, which is enumerated in the Constitution, the First Amendment, and, protection from unreasonable searches and seizures. That's enumerated. You can see that, in the Fourth Amendment. But the court here in the Griswold case is going to assert that we have an additional right known as the right to privacy. Now, you might be thinking, what do you mean? The court's just making up rights? Well, no. If you study the Constitution, in the Ninth Amendment, it says that other rights may exist beyond the ones that are enumerated. And this is an example of the court saying, yeah, here's one that isn't enumerated but exists nonetheless. That's the right to privacy. And the right to privacy is, in many respects, an extrapolation from the Fourth Amendment protection from unreasonable searches and seizures. That, in other words, when the government is denying you the ability to purchase contraception, it is, unreasonably invading your, life, behind closed doors, what you do with, other consenting adults in your bedroom. And so this was seen that Americans have that innate right to privacy to be able to do what they want with consenting adults behind closed doors. And it's not the government's right to tell folks what they can and cannot do with regards to decisions regarding, whether or not to conceive children. So this is going to be a very important case. And in fact, this case is going to be especially important, not just by the name of this case, but in fact, this will lay the groundwork for a much more famous case and a much more controversial case, Roe versus Wade. When Roe v. Wade, now granted, this is past the time when Earl Warren's on the court, but in 1973, when the court rules that women do have a legal right to have an abortion, it is predicated on the idea that abortion is a privacy issue, and you don't have privacy as a protected right without the ruling in the Griswold case. So the Earl Warren court's going to be a very significant time in American history. If you're talking about, the protection of civil liberties, a very liberal period of the court for sure. So we'll see you next time. Bye-bye.